Rồi, cả lớp mình bấm vỗ tay cho nhóm thuyết trình một tràng vỗ tay đi nào. Okay, good, thank you.
So, hi guys, I am Phạm Trung Tín and I will represent my group, my Pineapple group, to introduce to you some of the very first part of the incorporation of company in UK, Malaysia, and in Vietnamese law. So, my group member beside me is include Nguyễn Ngọc Trà My, Nguyễn Tấn Vĩ, Phạm Thành Đạt, and K.Anh. So let's take a look on this chapter outline. In today's lesson, we will study with 7 main topics, which is include introducing for some basic term and concept about incorporation of company and step to incorporate a company. Also, we will talk about a type of company that may be prohibited to incorporate. And the thing that's most important is the company number and name. And we will talk about this for quite long time. And the last three things that we will talk about is company member and its share capital and also its director. So, although we have learned about company and some basic definition about company, but I will cover it once again for you guys to avoid misconception and like informational clutter. So a company is a registered legal person. So if you say that company is just a legal person, is not right because it can be limited liability partnership. A company must be a registered legal person, which for the legal person to be a legal person, it means company can have its own assets and also liability, and also it can represent its owner to be assigned in a contract. A company is categorized by the following things. The first is about the shareholder liability. So for if a company have its assets connect with its shareholder, we call it unlimited liability company, and limited liability company is a company that have its assets separate from its owner, and also it has separate obligation and other things. For limited company, we have two types, which is a public one and a private one. For a public one, a public company is mean that company can offer stock to a public. It can also issue stock to some stock exchange market. But for a private company, it's the member of that company still can sell the share, but it has to, the share must be sold to a specific person. It's just like a transfer to a specific person, not to publish it and wait for someone to buy the share. So this is some of the visualization to help you to understand better about the limited liability of the company. So a company, to form a company incorporator must register it with some department. name of the department is different for every country, and we will talk about this in some later part of this presentation. So the process of set up a company and register it to the state is called the incorporation of a company. And in the next part, we will talk about what the incorporator do in that process. And my friend K.Anh will introduce it to you.
Okay, everyone. The first step we need to talk about is the registration procedure. This is now in order to register a business following the law. First of all, the business have to register their companies, the business companies into the like the labels and the trustful register form that created and based on the law, and send them directly to the registration authorities places. In these places, there are many names that we can call based on the countries that we stay in. And here's a detail of the places that we apply for the form. That in the UK we call it is a company house, and in Malaysia we call companies commission or SSM, and in Vietnam we call it the business registration agencies. And you also know that the registration, they have their own benefit that you might consider. First of all, is the officially recognized as a company. This is not the kind of the sole priority ships or say sole traders, as we know that they don't have the official forms of the benefit that they can earn from the from the regulations and the laws of the countries. And the second is that businesses may or more likely want to work with you because you show that the registered companies may show in some special like from like a special forms, and in the oh my God. And the third one is getting a bank benefits, because most of the capital banks, they might believe in your incomes, and they might know that what's your outcome and your plans in the future. And your company might get more trust from them. And for some liabilities might be excluded for some special cases, and they can support you. Most of the third parties come from the third party. In some special case, just like insolvencies, that the company can go to bankrupt. And now we move on to the registration requirement. First of all, we need a business name. In this form, that the business name must not be related or could make a mistake with the other business that already formed in the like they registered before us. And the second is locations. The location, we could apply for the business in any locations that we signed in the form, and based on the form, the location, they could be published and recorded by the law and become the trustful place. And the second is the ownership. For this part, the ownership is shows like how can I say, it's just like a partners that they own the companies. They could be in a partner. They run many parts in a company and contribute to their functions. And the fourth one is the registered agent information. It's usually described as the third party outside a company who have a direct support to the like a currencies or some relatives to the companies that could help gain more benefits. And the fifth one that we have to consider is the number and the value of shares that we based on the ownerships and the agents outside the companies that they will support us in order to share a benefit that will like accumulated benefits that will satisfy all of them. And then could you please change the slide? Okay. Now here is the registration form that following in the UK law has been shown for you. In some of the detail of this form, there's something that we need to consider. First is the MOA, the Memorandum of Association. This is a document showing the cooperation relationship of the individuals outside the company. They usually bring contribution to the operations inside a company throughout their outside support, just like the service or their products that could help boost up the company. And the second is the AOA, or we can call it the Article of Associations. Is the document that regulates the operation of a company and define the purpose of the company. But the document that shows that how tasks that within the company will be accomplished, including the appointment process and financial handling. And next to that is the based on Malaysian law. There are three things that we have to consider at the end of the detail of this form. That's the detail of the directors and promoters. This kind of promoters we can understand as that's beside the directors. There are many people that could be could support the directors, just like a secretary. And the second I want to consider is the declarations from directors and promoters. Is the declaration from the director and promoter. That's the different. That's the directors may against the rights, and then they can promote to the next to the size people that's then supporting them. And the declarations of compliance from individual responsible in incorporations. For this individual responsible for incorporations, we can understand that's for some special ownerships. They have for all of them might have the responsible for the incorporations based on the plans and the liabilities may have in the company. And in the last is the up in the Vietnamese law. We have the identity form. The identity form is separated from a foreigners and the native Vietnamese. Like the identity form for native Vietnamese, it could be for foreigners. It could be like they have to support their they have to support their personalities based on the countries where they come from, like visas, and for some special cases that they have to identify for the form of the company based on the law that has given in Vietnam. And continue to move on is the examples of the form that's in UK, Malaysia, and Vietnam for you. Then could you please change the slide? Here's the form. Yes, as you can see, there are significant difference to the form of each country, but overall, they all have the same purpose. And next to that is the example of the applicants to register a company. This is applications is short in one of the form that we apply to open, like register the companies, as you can see below. Then could you please? Here, and here's the form for you. Okay, now we move on to the prohibited types of company. That we will continue to the next person.
So before my partner take over the next part of this presentation, I would like to share that like when a parent gives birth to their baby and then they go to the government to have the birth certificate for that baby. So the certificate of incorporation is like a birth certificate for a company, which is present for the incorporation of a company which is named on that certificate. You can see here that each country have different type of certificate of incorporation, but for Vietnam, it is have a more specific one where it also have information of the founder of that company, and the certificate of incorporation for Malaysia and the UK of company house is quite similar to each other. And talking about the company house, so when the incorporator go to the register to incorporate their company, so they will receive a form which is called the IN01 application form to register a company, which is they will put in the company information. And as you can see here, one part of that form, which is the incorporator will choose which type of company that he want to incorporate. So beside of this company, this type of company that you see here, there are some type of company that is prohibited to incorporate in UK and maybe in Malaysia. And my my teammate me will show you about that in the next part of this presentation.
Here is some prohibited type of a company. Now we will give in the information compared to the difference between UK law and Malaysia law. According to Malay Company Act 1965, according to Company Act 2006, Part 1, Section 5 in the UK law, the company limited by guarantee and having share capital. This applies whether or not the nominal value or number of the share or interest in is specified by the provision. About the Malaysia law, according to Malay Company Act 1965, any two or more persons associated for any lawful purpose may be by subscribing their name to a memorandum and complying with the requirements as to registration from an incorporated company. A company may be a company limited by guarantee or a company limited by both share and the guarantee. About the prohibition of unincorporated association of more than 20 members for gains. An associated or partnership will not be formed for the purpose of carrying on any business which has for its object the acquisition of gain by the association or partnership or the individual member theory unless in the case of any other association or partnership, it consists of not more than 20 members.
So we have learned about some of the type of company that is prohibited to incorporate in Malaysia and in the UK. So now we will moving on into the next part of this presentation, which is about some of the factor, some of the detail of the application form that a applicator must consider. Some of the, as you can see here, is the first page of the application form IN01, which is, we can see on the first page, the company house required the incorporator to give their company a name, but because of the restriction of the law, the incorporator cannot freely name anything that he wants, and that it will be what we will study on this part, name and number of a company. And my teammate that will cover about the number and limited on company name, as well as passing off an objection to a name based on goodwill of this part.
All right, hey guys, my name is That. I will continue on the past presentations. First is the company number. All right, every company is registered is its own number. This number appears on the certificate to the incorporation and the register of the companies. And the second is used for the business and production activities. The company's number dash is competent state agency in the charge of registration of the company establishment to the rent to the enterprise for the that enterprise to the use throughout the course of its business and production activities. And the third is the can code instead of the name. It can very difficultly to know which company interests into the agreement if after entering into the agreement the company changed its name, and it's very particularly too confusing where a company's name is changed and its old name is given to a new company. It's an identification difficulty can be avoided by including the company name number as the part of the identification of the company. It's rather than it's the relying on the referring to the company by its name. All right. Next is the company name. Here's the first, the complete, the legal name of the company, the title by which company the solemnly organized and incorporate to know as a legal entity. Well, the first is must be clearly displayed at the legal or the register office, the company, and show on all the official document as an agreement. And the second is the business name is an image, also is an asset that creates the company's brand. So under this one is have the partners find it easily and accurately to promote business development. So the naming is of the business need to pay attention, avoid mistake, confusion, or dispute arising later. It's affecting all the business and the production activity or the interest of the each enterprise. All right, we are move next is choosing a company name. The limit on the company name. So the first we have the legal issue. All right, issue in the relation to the company names and the company business name fall into the four categories. The first we have the limit on a company name. The second we have the procedure for the changing company names. The thirdly we have a trading disclosure, and the last we had regulation of the business name. So we have more detail on the next part. So the next part we have the limit on the company name, the risk chart of the company to the reviews to the register certain the company's name, and the security of the state to the direct that company name to be changed in the certain the circumstance. A company name is the adjudicator to the order that the company name will be the good change and on the successful application by the person with the goodwill. All right, we have the registrar of companies right to refuse to the register name a name. We have the first. We have the prohibited name. This is one a company must not be to register by a name if in the opinion of the Secretary of the State is the use would the constitute of the offense or is it a very offensive. The second is approval of the name by the Secretary of the State. It would be likely to give that impression and that the company is connected with her Majesty government, is a local authority or any public authority specified in the company limited liability partnership and business name is include a tentative word expression list to those regulation unless is evidence to the produce that the name has been approved by the SS. The thirdly is we are prohibited charter. Prohibited charter have companies maybe not registered by a name that include any charter, a sign, a symbol, and the fund totation or the placing of number is therefore that not permitted by the CP and MP regulation on 2009. And the fourth is indication of the company type or the legal formed by the limited company. This is one of the company name must indicate the type of company is it in the main manner provide for the act. The fifth is the inappropriate use the indication of the company type or a form. This one as company must not be registered by the name that includes the specific word and expression or order indicate and associated with the particular type or the company or from the organization or the word similar to the date to the prohibited by the SS. And the last one is the name the same as the name of the existing company. This is the last. Alright, the register of the companies will not register a company with a name that is the same as the same name on the company register. This is according to law, the Company Act 2006 and the CPN regulation on the 2009 to contain the guidance as to how the register will approach deciding whether or not one the name is the same as an order for the desk purpose and provision to the ensure that the trivial the trivial difference and between the names will be included by the register of the companies. All right, move on the next. The security of the state right to the direct that a name be changed. Or the first we have on the company increasing to the be the entitled to the exemption from the requirement to the end, and its name is will limited. If it appears to the security of the state that the company whose the name does not include the limited or any permit at the time has the credit to be entitled and to the impenssion. The second is that the name as the or like the name of the existing the security of the state direct a company to change is the name it has been registered and in the name that is the same as or. The thirdly is misleading information give for the purpose of the company's registration with the particular name. If it appears the security that the misleading information has been the gift for the purpose of the company's registration by a particular name, or we had that an undertaking or the assurance has been given for that purpose and has not been definited. The last one is the misleading indicate of the activity. If the opinion of the security of the state, the name by the which a company is the register to the give misleading and indicated of the nature of the activity to be likely cause harm to the public, the security from the state may direct the company is to change the name. So we have the next is it's very important to choose a company name that will not leave the company name to a company open to the challenge based on the agreement that conduct of the business under name. So interfering the intellectual property rights of or a person. Hello then. All right, there is the right include those that may not be limited to the right to bring action for the infringement of the registered the trademark and the right of the trader to the bring tort action for the passing of. Okay, what is the passing of? Passing off is the bring against any person who the misrepresentation sent to the public that the goods or the service is the representing person is the providing or the associated with the claimant trader, and thereby is causing the damage to the claimant trader. The claimant traders must demonstrate that it has goodwill and has been damaged by the misrepresentation. And a goodwill is goodwill refer to the all of those attributes of the business that is attract and retain customer that by accounted for the elsewhere. The merely calling the company a name never amount up the passing off. All right. Then okay. But okay, what is a goodwill? Goodwill is an item that it can be found in the asset section of the company's balance sheet. The goodwill can arise when one company acquired by the order, or the goodwill is an is tangible asset of the business that can be bought and sold. So during acquisition of the amount payable, that's for a company's book value often depends on a tangible asset of the target company. And the goodwill is considered an tangible asset on the balance sheet because it is not a physical asset as plant or equipment. The goodwill very often reflect the value in the intangible asset such as a strong brand, customer relationship, or the good employee relation, or any prevalent patent or technology. All right, move on to the next. The legal protection given to the owner of goodwill has been exchanged. That is a company law review. The applicant must be established that respondent company names and is the same as a name associated with the applicant in which it has a goodwill. The concept of a goodwill is intended for the purpose of the such application, the being defined at the 69 to the 7 to the include by reputation of the any description. The prohibition has been drawn very narrowly, and objection cannot be upheld, and no order that a company name change can be made, or if the respondent company establish any one of the following the 5 defenses. The first, we have the name. The name will register before the commencement of the activity. The second is the respondent company. The third is the name the word registered in the ordinary. The fourth is the name was adopted in the good faith. The last is the interest of the applicant are not adversely affect to the any significant to extent. So any decision of the company's name whether adjudicator and maybe the appellate to the court. So we are Nguyễn Ngọc Trà My will on the next part.
Give an applause. Okay, please.
Hello everyone, my name is Amy and I'm in Apple Group. Today I will continue the last presentation and I will give you the information to have deep insight into the procedure to change a company name. A company want to change their name, they need to passing a special resolution. The company must be approved to secure shareholder approval of the new names and is were mentioned in Company Act 2006, Section 77. A company want to change their company name, they must pass a special resolution, and there are two ways to organize a special resolution: a general meeting and a written resolution. In a general meeting, for a special resolution to be passed, a majority of at least 75% of the eligible must vote in favor of it, and in written resolution. This way is similar to a general meeting. Resolutions will be adopted by a majority of not less than 75 of the members eligible to vote, and it was mentioned in Company Act 2006 and in the section 283 special resolution. When a resolution of the directors have been passed, a certificate of copy of the resolution must be delivered to a company house by post within 54 days along with Form NM01. Look at to the slide and you can see the Form NM01 for approval by shareholder resolution. So what happened now? What happened when the company house approved? As soon as your change of name request have been approved, company house, they will enter the new name on the registers and issue a certificate of incorporation on change of name. And then your new company name will become effective from the date on the certificate of incorporation on change of names. And you must remember that the certificates of incorporation on change of name do not replace the original certificates of incorporation. All of information that I mentioned about as specified in Company Act 2006, Section 18, change of names, registration, and issue of new certificates of incorporation. After you change of the company names, the effect when you change the company name according to Company Act 2006, a change of company name has effect from the date of the new certificate of incorporation is issued, and the business continue to maintain its rights or obligations in the event of a name change. And last but not least, a change in name will not deter a company or legal entity. Any legal proceeding that might have been continued or commenced against it by its former name may be continued or commenced against it by its new name. So what does it mean? The easiest way to understand that the company with the old name is executing a legal penalties. When changing the new name, the company must continue to maintain that penalty. So we move to the Malaysian law. The procedure to change company name in the Malaysia is similar to the UK law. In the section 23, the change of name, a company may by special resolution resolve that its names could be changed to a new name if the registrar approves the new name. A certificate of incorporation of the company under the new name and upon the issue of such certificates of incorporation, the change of names will become effective, and a change and a chain of name persons to the art will not affect the identifier of the company or any right or obligation of the companies. Any legal proceeding that may have been brought against it by its old name may be continued against it by its new name. You can see that the process of change company name in Malay law is quite similar to in the UK law. We move to the procedure to change company name in Vietnam. There are 4 stages in the procedure to change a company in Vietnam. An enterprise can change their name during operation. The change of name is according to the needs of the business. The first step, the naming is clearly regulated in section 9, in the section 39, 40, and 41 of the Vietnamese enterprise. Yes, you can look to the slide, and this regulated in the section 39, 40, and 41. In the next step, prepare a file to change the company name, including a copy of the meeting of the members' council for the company and the resolution on the change of the enterprise names. Next step, submit the application files and the fee for changing the company name at the business registration office where the company head office is located. And finally, upgrade the seals if you change the Vietnamese names. Okay. We have finished understanding the information in the process to change a company name in 3 countries. So we will move to the new section, the business names used by companies. A company name is a name used in the course of carrying on a business, just as a sole trader may carry on business under his own name or name different from his personal name. And a partnership may trade under the names of the partner or name different from the names of the partner. So the easiest way to understand that a company may trade under its company name or a different name. Next, please. The art of knowledge we will learn in this lesson is name and the fairness syndrome. The fairness syndrome describes a company that had gone into insolvent liquidation, having run up significant debt, and its assets having been transferred to the second companies. This ambitious the imagery of a new company arising out of the flames of its financially burned out predecessor. What's lighting? In the Insolvency Act 1986, Section 216. No, I need the old slide. Cái cũ. Không phải cái này. Yeah, right. Insolvency Act 1086, Section 216, which prohibits a person who were a director of a company that had gone into insolvent liquidation from being a director of or otherwise being involved in the following 5 years in the management of a company or a business with a prohibited name. Look at to the slide and here is a case study in this session. It makes you easier to visualize what I just said. You can see in the slide there are two companies. They are the director of the companies. The director of the company are Ed Valorum and Ricketts, and Air Communal Company and Air Equipment Company respectively. And two companies have gone into insolvent liquidation. And an employee of Air Equipment Company sought to collect a debt from the defendant on the basis that the name of the second company were a prohibited name of Insolvency Act and filed a lawsuit in court. The defendant was personally liable for the death of the second company. Okay. Or have the second company name were similar. Quay lại ơi. The second company name was similar to the name by which insolvent company were known as to suggest an association with the second company name was so similar to the name by which the insolvent company were known as to suggest an association with the first company and were therefore a prohibited name. Thus being the conclusion, the courts had no discretion to exercise the director were personally liable for the debts of the second companies, and my teammate will continue the presentation.
Okay, wait. Okay. Thank you. I personally liked your presentation a lot, like your parts a lot. So before I get in, can I know what is the content of the next part, please?
The next part we will talk about the minimum requirement of member
Capital.
and director and company share capital, and we will not talk a lot about this. We will talk at a minimal level that is enough to incorporate a company.
Okay, so I think you finished the part about company name, right?
Yes.
Okay. So let me wrap it up a little bit, and you will continue. Okay. So the whole class, please pay attention to this part because it's rather important to the process of incorporation of the company. Okay, so thầy giảng luôn bằng tiếng Anh được không lớp? Được không? Hay là thích tiếng Việt hơn? Thầy giảng luôn bằng tiếng Anh nha. Okay. Okay, so I guess what we were talking about, what we have been talking about for this whole time was how to incorporate your company. And one or two of the key things that you okay, so I guess our class will have maybe I think our class will have up and downs. I have seen somebody have asked me to speak more English because they want to learn more English. So thầy sẽ cố gắng strike a balance between the two languages. Okay. Okay. So basically, what we were talking about this whole time was how to start a business, but in a procedural way. Procedural. Quy trình và thủ tục để bắt đầu một cái company. Ok, thì những lần trước thì các bạn đã mention những cái ví dụ như là cái form mà các bạn sẽ phải điền và nộp về đâu để có thể đăng ký thành lập. Và sau khi mà hoàn tất cái quá trình đó thì các bạn sẽ nhận được những cái registration form như thế nào. Thì thầy rất là ấn tượng với phần trình bày của Trung Tín và Mai Kỳ Anh. Bởi vì các bạn có nhắc đến cái registration form, các bạn thậm chí là có cái hình ảnh minh họa của cái registration form luôn, khá là sinh động, đúng không? Rồi ok, rồi and then we move to the next part. We have Prohibited Company, okay. We have the name of the company. Và thầy thấy là chúng ta dành khá là nhiều thời gian để bàn về cái company name. Vì sao là như vậy? Bởi vì cái company name á các bạn, nó basically nó là một cái thứ mà tất cả mọi người sẽ biết về cái company của bạn. Cho nên cái việc đăng ký nó trở nên rất quan trọng. Cái thứ nhất, tên của cá nhân thì có thể trùng nhau. Các bạn nhớ dùm thầy ý này nè. Mặc dù mình nói á, the company với lại the individual là nhau. Nhưng mà trên thực tế á, tên của cá nhân thì có thể trùng. Nhưng mà tên của company là về nguyên tắc là không được phép trùng nhau. Trên thế giới này không được phép có hai cái company nào đó tên y chang nhau. Về nguyên tắc nha. Về nguyên tắc là như vậy. Khi mà cho nên là bởi vì sao? Bởi vì nó xuất phát từ cái lý do là gì? Đó là cái mà để customer sẽ nhận diện công ty của bạn. Ok, và nó còn liên quan đến một cái thứ nữa, đó là business name, tên thương mại, hay có nhiều người gọi là trade name, tên thương mại. Thì cái tên thương mại có thể nó sẽ không phải là tên của company, nhưng mà nó sẽ ảnh hưởng đến việc là người tiêu dùng recognize cái nhãn hiệu, cái thương hiệu của bạn như thế nào. Thầy lấy một ví dụ ha, lấy một ví dụ các bạn hiểu liền. Ở đây có ai biết công ty cổ phần trà và cà phê Cao Nguyên không? Công ty cổ phần trà và cà phê Cao Nguyên. Rồi, nghe tên hình như không biết. Thầy hỏi câu thứ hai, ở đây có ai biết Highland Coffee không? Ai biết bấm giơ tay thầy coi. Rồi, biết, ok. Rồi, ok, thank you very much. Ok, tiếp ha. Ở đây có ai nhớ đến cái logo của Highland Coffee không? Khoan, một phút. Đây, thầy có ngay đây là một phút. I have right here. Ok. Thì đây là cái logo của Highland Coffee. Thì bây giờ thầy nói cái logo cái là các bạn nghĩ tới cái này liền đúng không? Right. Rồi bây giờ phân biệt làm sao giữa ba cái thứ. Thầy đừng nhắc tới em thèm quá đi. Lêu, tôi đặt được cái ly này về nè, lêu. Rồi ok. Thảo này nó chọc thầy hoài, tôi ghim, tôi cố tình tôi chọc nó. Ok rồi, như vậy phân biệt ba cái thứ này như thế nào? First, cái logo Highland Coffee á, nó là cái mà người ta gọi là nhãn hiệu, trademark, viết tắt là TM. Biết cái đó không? Viết tắt là TM, trademark. Thì trademark dịch tiếng Việt mình là nhãn hiệu, đúng không? Nó là cái các bạn sẽ phải phân biệt giữa ba cái khái niệm này. Tên công ty, ok, tên thương mại và nhãn hiệu. Trong tiếng Anh là company name, business name and trademark. Ok, cái business name còn có một từ đồng nghĩa khác là trade name. So, company name, trade name, trademark. Các bạn thấy trade name với trademark nó giống nhau. Nó là vì sao? Trademark là cái hình thức thể hiện ra ngoài của cái thương hiệu. Còn trade name là cái tên để người ta gọi cái thương hiệu của bạn. Cho nên cái thương hiệu á, là cái rất là trừu tượng. Còn thể hiện ra ngoài á, thì một cái tên của thương hiệu á, là sẽ được gọi là trade name. Ví dụ thầy nói với các bạn Highlands Coffee thì nó là trade name. Nó chả phải là cái nhãn hiệu. Cái nhãn hiệu là cái logo có cái hình đó, thì cái đó mới là cái nhãn hiệu. Còn cái trade name là cái mà mọi người bàn đến, là cái mà nó dùng trên các cái tiêu đề logo, đúng không? Nhưng mà tên công ty của nó khi mà đăng ký trong sổ của phòng đăng ký doanh nghiệp á, thì nó là cái gì? Nó là công ty cổ phần trà và cà phê Cao Nguyên. Như vậy các bạn phân biệt được cả ba cái này. Rồi, về nguyên tắc cả ba cái này thì trên thế giới bạn chỉ có ba cái này á, trên thế giới chỉ được phép xuất hiện một lần. Bạn không được phép xuất hiện công ty trà và cà phê Cao Nguyên 2. Không được như vậy. Bởi vì nó sẽ đụng đến hai cái nguyên tắc khi các bạn đặt tên của một công ty. Nhớ giùm thầy Tứ hai nguyên tắc này. Hai cái nguyên tắc khi các bạn đặt tên công ty. Một, ai đến trước thì được trước. Ai đến trước thì được trước. Câu này nghĩa là sao? Câu này nghĩa là nếu như thầy nghĩ ra một cái tên thì thầy có quyền đăng ký nó nếu như chưa có ai đăng ký. Sau khi thầy đăng ký xong, nếu như lỡ ý tưởng lớn gặp nhau, một người khác cũng muốn kinh doanh ngành nghề này, cũng muốn đặt cái tên này, thì sao? Không được phép đặt nữa. Bởi vì thầy là người đến trước, em chỉ là người đến sau. Ok. Nguyên tắc thứ hai, không được trùng với tên đã có. Yêu thầy vậy?
Thầy ơi,
Ai bấm tắt tiếng thầy vậy? Đứa nào để tôi trừ điểm coi. Nó chê tôi giảng nhiều phải không? Ok. Không được trùng đến mức gây nhầm lẫn. Và đó là hai cái nguyên tắc khi bạn đặt company name. Và that is the reason why cái phần mà Trà My hồi nãy nói á, là cái chuyện mà đặt tên thì hôm trước là bạn Đạt bạn ấy nói ha. Đặt tên thì bạn Đạt bạn ấy nói. Cái chuyện đặt tên, rồi chuyện đổi tên và chuyện thừa kế cái tên, đúng không? Nó phải là những cái bạn phải làm hết sức nghiêm khắc. Để vì lạng hoạn là bạn sẽ đụng tới prohibited name. Prohibited name. Cái chuyện prohibited name bữa trước bạn Đạt có nói á, là nó còn đụng chạm tới một chuyện nữa các bạn. Các bạn không được lấy những cái đã có sẵn mà đặt tên cho tên công ty của bạn đến mức gây nhầm lẫn. Những cái đó bao gồm là những cái thực thể đã có thật. Ví dụ bạn không được đặt tên của một quốc gia cho tên công ty của bạn. Tôi không được đặt tên là công ty cổ phần Cộng hòa xã hội chủ nghĩa Việt Nam, đúng không? Không được đặt như vậy. Tôi cũng không được đặt là công ty cổ phần Liên bang Hoa Kỳ, chắc chắn là không được. Rồi một cái nữa là bạn không được đặt từ ngữ thô tục cho tên company của bạn, chắc chắn rồi, bởi vì cái đó là yếu tố ảnh hưởng đến thuần phong mỹ tục, right? Ngoài ra thì bạn không được đặt vào những cái tên mà trong một cái list người ta sẽ có prohibited name, thì tuần trước bạn đặt ra nó rồi. Okay. Rồi nói đến chuyện đổi tên thì hồi nãy bạn Trà My cũng có nói, bạn đổi tên thì bạn phải đổi bằng một cái resolution, chứ không phải ai thích đổi là đổi. Cái này xuất phát từ việc là cái gì này? Một cái company á, là phải có nhiều người làm cùng nhau. Mà nhiều người làm cùng nhau thì một cái quyết định đổi tên của cả một cái company sẽ phải được thể hiện bằng cái gì? Bằng cái quyết định chung của tất cả những người đó. Right? So you have to show an evidence of your agreement. Okay? That document is called resolution. Resolution. Nhóm nào mà làm về private limited company sẽ nói về cái phần này. Shareholders hay là directors gì đó sẽ nói về cái này. Ha. Resolution là cái gì? Biên bản họp của cái đại hội đồng cổ đông. Hồi nãy bạn My cũng có nhắc đến một khái niệm rất là tốt ha, đó là shareholder meetings, general meetings. General meetings là các cái cuộc họp đại hội đồng cổ đông đó. Thì tại cuộc họp đó họ phải nhất trí thông qua là sẽ đổi tên company và phải thể hiện ra bằng một cái resolution. Thực ra là có thể họp tại chỗ và có thể bằng hình thức là họp tại chỗ, hoặc là hình thức lấy ý kiến bằng giấy nữa các bạn. Tức là không cần thiết phải tổ chức họp, mà họ chỉ cần gửi cái form đến nhà của các cổ đông á, hỏi là có đồng ý hay không, đồng ý thì ký vô, không đồng ý thì thôi. Rồi ký vô xong gửi lại, họ sẽ thu thập những cái phiếu và tính phần trăm cũng được, không nhất thiết phải họp ha. Nói chung nó ra được một cái resolution. Và cái resolution đó trong vòng bao nhiêu ngày? Hồi nãy Trà My nói bao nhiêu ngày? Các bạn nào nhớ Trà My nói bao nhiêu ngày không? Hoàng Minh nhớ không? Đúng rồi, Hoàng Minh nhớ không? Trong vòng bao nhiêu ngày thì phải gửi cái form này qua bên Company's House? Hoàng Minh nhớ không? Nãy Trà My nó nói rồi.
Không nhớ thầy à.
Không nhớ nha. Ai nhớ thì cho một điểm cộng liền. Không ai nhớ hết luôn. Nãy giờ Trà My nói không ai để ý hết hả? Tội nghiệp Trà My quá vậy. Vậy thầy hỏi lại Trà My đi ha. Trong vòng bao nhiêu ngày thì phải gửi cái resolution này qua bên cho Company's House ha? Thầy thấy là ai có ai đó đây. Trà My show đáp án cho cả lớp đi.
Dạ là 15 days.
15 days, 15 ngày. Thank you very much. Trong vòng 15 ngày, tức là hơn 1 tuần. Sorry, hơn 2 tuần là bạn sẽ phải gửi cái document đó qua bên Company's House. And then the Company's House will decide. Bạn cũng nhắc đến một cái trường hợp rất là thú vị, đó là gì? The Phoenix Syndrome. Phượng Hoàng nó nổi tiếng vì khả năng gì các bạn? Phượng Hoàng nó nổi tiếng bằng khả năng gì? Con Phượng Hoàng hồi sinh, đúng rồi. Nó cháy thành tro xong rồi nó hồi sinh, đúng không? Ai coi Harry Potter sẽ biết. Con Phượng Hoàng của ông hội trưởng đó, đúng không? Ok. Nó cháy xong rồi nó hồi sinh. Cái này nó là được tượng trưng cho cái việc gì? Một cái công ty á, nó run out of asset, nó phá sản. Thì nó phá sản. Thì bây giờ khi mà nó phá sản rồi á, nếu như sau đó nó có cái khả năng gọi là cái gì? Khi mà nó có khả năng trả lại nợ, nó có thể tiếp tục cái công việc của nó, thì coi như sao? Coi như là hồi sinh. Nó có thể có lại được cái tên đó, nó có thể tiếp tục làm việc với cái tên đó, nó có thể tiếp tục kinh doanh với cái tên đó. Ok. Nhưng mà có một trường hợp này xảy ra vậy này. In insolvency, cái câu chuyện về phá sản insolvency là câu chuyện về giải ngân và thủ tục thanh lý tất cả các tài sản còn lại trong công ty. Vậy thì nếu như có một anh nào đó ảnh nhận phần lớn các cái tài sản của công ty cũ chuyển sang, ảnh nhận phần lớn các tài sản công ty cũ chuyển sang, rồi ảnh tiếp tục kinh doanh, rồi ảnh lấy một cái tên gần giống như cái công ty cũ đó để tiếp tục kinh doanh trong ngành nghề của công ty cũ đó, được không? Có được hồi sinh lại cái công ty cũ theo cách đó hay không? Thì hồi nãy Trà My đã cung cấp cho mình một cái answer khá là tốt. Và cái thầy thích nhất là Trà My, trong cái phần của Trà My là có một cái case study. Đây chính là cái cách mà các bạn làm case study. Các bạn liệt kê ra các cái facts, sau đó các bạn bắt đầu phân tích ra chút xíu, rồi các bạn cho biết là tòa án đã hold và held, có nghĩa là đã phán quyết như thế nào. Ok, thì trong cái trường hợp này, bởi vì nó là hai cái company khác nhau, và the second company, cái tên của nó là nó đã bị dính vào cái gì, cái trùng hợp đến mức gây nhầm lẫn. Ok, thì nó sẽ rơi vào trường hợp nó là một cái prohibited name. Ok, cho nên cái này không có rơi vào cái trường hợp đó là được phép thừa hưởng cái tên của company, nó không phải là cái Phoenix syndrome. Và các bạn nhớ là cái Phoenix syndrome này nè, cực kỳ hãn hữu, tức là cực kỳ ít được áp dụng trên thực tế. Bởi vì một cái công ty nếu như người ta đã chết rồi thì thôi. Và thậm chí là bị một cái nữa các bạn, cái này thầy chưa thấy nhóm nói tới, nhưng mà cái này mình mở rộng thêm. Một cái tên của company á, ngay cả sau khi company đó đã chết, đã giải thể, đã phá sản, thì người ta cũng không được phép đặt trùng lại với tên của company đó. Trùng đến một mức độ nào đó thôi, nhưng vẫn không được phép đặt tên trùng hoàn toàn với tên cũ của company đó, dù company đó đã chết, bởi rất nhiều lý do. Và lý do gì thì các bạn sẽ phải tự tìm hiểu, chứ thầy không giảng nữa. Ok, very good me once again, and Đạt and Tín, very good. Now please move on.
So in the next part of our presentation, we will talk about the company members, its director, and also its share capital. But we will talk about it just at the minimal level. We will not talk so deeply into it like for the governance part of the company. We just talk it to provide you a sufficient amount of knowledge to incorporate a company. But when you read a textbook on the incorporation of a company part, you will not find is part about member, director, or company share capital, but we will just cover it here to give you some information about these three things. So now my teammate Vĩ will talk about his member for me. Let's go, Vĩ.
Hello, các anh nghe được không ạ?
Okay, I hear you.
Okay.
Very good.
Next question. Next question. Đợi một chút ạ. Đợi cho em muốn miếng nước.
Vĩ, take your time.
Dạ.
Take your time.
Next question. We go to who we consider a member of a company.
Okay, Vĩ, now listen to me. You take a deep breath. Hít thở sâu. Okay.
Không
And
phải
then
em
go on. Bình tĩnh,
bị
làm sao
cảm thầy. Em bị ngạt mũi chút.
Cảm hả? Ok.
Do cảm hư.
Giữ nha. Okay.
Yeah. Who we consider as a member of company. Member are the owner or co-owner of the company. Company member are one of the goal for being the company as well as the company operation process. Every other person who arrive to become a member of company at whose name is entered in its register Registry of member is a member of Company Act 2006, Part 8, Chapter 1, Section 120. Register of member usually corporate membership if formed by the following way: it contribute capital to the company. This is the main role to become a company member. Receive the transfer of the company capital contribution. Interhigh donating asset is a capital contribution. Being the from the asset contributed by member of the company. Next, we go to the maximum and minimum number of for object of company. They find command tab of company. The GSC Jobsoft company mutant member limited library company 2M double AC single limited single limited limit liability company partnership and private enterprise. Short company at least three shareholder and no resistance to the maximum member, the same like pháp luật Việt Nam. Mutant number limit library company it must have at least 2 members and no more than 50 and can both individuals and legal entity. Single limit library company, only one member is requisite agent and invest on the legal entity. Partnership is at least to a limit library partner only in individual and no resistance to the maximum member, no resistance to the minimum and maximum number of limit library partner, and private enterprise only sole individual owner. That's all.
So we have just learned about about who is considered as a member of a company according to the law in UK. So in the next part, we will learn about who is prohibited to be a member of a company. So basically, a member of a company is the one who owns stock of its company. But not everyone, every legal person can buy stock of other company. Like in this case, in the section 136 of Company Act 2006, there are a rule in which is a subsidiary company is prohibited to be a member of its holding company. in Vietnamese term, the subsidiary company is called công ty con, and its holding company in this situation is công ty mẹ. So basically, the subsidiary cannot own share of its holding company, and it is the same case in Vietnam, where it's prohibited its subsidiary to own share of its holding company. And in Vietnam, there is more rule on the subsidiary and its holding company, which is if a subsidiary is from a company which has 65 or more percent of state capital, it cannot buy and own share of other company. And also the subsidiaries from the same holding company cannot buy and own share of each other. And in Vietnam, there is also the rule in which some government and state people cannot be a member of a company. It means they cannot join in a company or own share of a company or incorporate a company. So
Okay, excuse me. Okay, excuse me. Class, the whole class, please pay attention to this part because this part is very important. Okay, so please go on.
So so we know that the people of the government and the state people are the one who can make regulation and make rules on the business. So in order to ensure that the regulation they make is not for their own profit, so the Vietnamese law need to separate these people from the company, so they all make the rule in which the state authorized and people are forced using state-owned assets to establish enterprise to save their own interest is not allowed in Vietnam. Moreover, the official and public employees is also cannot incorporate a company or own share in other company, and the commissioned and non-commissioned officer or the career military personnel cannot also do the same things. So here we have talked about the people is prohibited to be a member of a company because of their power and their authorized to make law. In the next part, we will talk about people who is banned from being a member of a company based on their characteristic, their status. It is include people who facing a criminal prosecution and is being temporary detention or currently imprisoned. Also, a person who is currently serving an administrative penalty in a correctional institution or rehabilitation center cannot also join a company. A person who has limited legal capacity or is incapacitated, has limited legal capacity or is incapacitated, is he or she cannot take responsible for what he or she do. And moreover, a person who are not able to control his or her own behavior, which is related to their mental clarity, is prohibited from being a member of a company. And especially if a person is specially banned by a court from holding a specific position in a company cannot also be in this position of a company. So the next part we will talk about the director of a company. So basically, a shareholder of a company is who own the share of his company. Do not, in most cases, do not actually run a company. So they select the director, maybe from the shareholder, from the group of shareholder, or they can hire the director outside of a company. So the question here is a director a member of a company? I think it's depending on if that director owns share of a company or not. So if they are not on share of a company, they are just a normal person, a director who work for a company, and they can also be kicked out from a company as usual. But moreover, they also have the ability to reject that kick out from the shareholder. Next, we will talk about the requirement on the minimum number of director in UK, Malaysia, and in local law. We will talk first about the limitation in UK. So in the section 154 of Company Act, the company they separate company into a private and public company, and the requirement is also different for each form of company, which a private company is only need one director to run its company, only not why a public company, which usually a really big company, need up to at least two person to be a director of its company. The thing is different in Malaysia when every company shall have at least two director, and they are the person who has their own principal or only place of residence in Malaysia. It is stated in the Article 122 of Malaysian Act on Corporation. In our local law, a company is required to have at least one director, regardless is a private company is a public company. So we have talked about the number. Let's talk about the nature of the director. So in the IN01 form of to incorporate a company, there has two places to register a company name and their information. There's two places for the director. One is for the natural person of natural legal person, and another one is for the corporate director appointment. Thầy nói gì hả thầy?
Không, đâu có, thầy đâu có nói gì đâu.
Yeah, em
Ai
nghe
nói đâu,
tiếng
mấy
gì
thầy
em
nói.
tưởng thầy nói.
Không, not me. Có ai muốn, okay, so có ai muốn đặt câu hỏi hay là cái gì trao đổi trực tiếp với lại nhờ bạn trên thuyết trình không? Nếu có thì các bạn có thể bấm giơ tay ha. Bởi vì bạn thuyết trình là hoàn toàn làm chủ cuộc chơi ở đây, cho nên là nếu các bạn muốn trao đổi các bạn cứ bấm giơ tay rồi bạn thuyết trình sẽ mời. Okay. Okay, if not, please go on.
Yeah, okay, so I will continue on the requirement of each country for the nature of a company director. In UK, there is required for a company to have at least one director who is a natural person. A natural person is like a normal person like us, and the corporate director is like you hire some company to be a director of your company. In Malaysia, they're more strict on the characteristic to the nature of the director, which is they are all prohibited a corporate company to be a director of other company, and there is only natural person can be a director of their company. Next, we will move on into the register of a director. So when a director is appointed in a company, there must be a register of that director for a company to keep. So in that register of a director of a natural person director, there must be include some information like their name, their service address, their country, which is they are currently in, their nationality, their business occupation, or their date of birth. So in UK law, the age of a director must be over 16 to be a director of a company. But for the corporate director, there's a different information that needs to fill in the register form, which is a corporate of a firm name, or the register principal of, or its register's principal office, or its registered number, and the legal form of the company or firm. So the director of a company do not necessarily be a other company. It can be other enterprise like sole trader or partnership. So here's a register of director. Is an example register of director that a company keep for their own, which is they will have the name of the director, and in the detail column there will be a some detail of its director, and in the third column there will be the date that that person be a director of a company, and also they will have the date terminated, which is about the tenure of a director. In the next part, we will talk about the share capital of a company, which is we will try to cover some basic term of a company share capital. So basically, when a owner or a shareholder of a company put money or a money worth things to the company, they will receive a stock and dividend, and also a certificate of share on or stock on, which is an evidence for that person ownership of a company. So here is a part of a IN01 form application, which is will describe that company initial shareholding. In this part, the subscriber, which is a member when incorporate a company, will list their name, their address, and the class of share that they own, and also the number of share that they own, and the currency and the nominal value of each share. And also they will state out the amount of paid and unpaid amount of a paid and unpaid amount of money that they have on their share. So here's an example for you to understand about something like nominal value of share or the number of shares that a company have. So let's assume that a private company have three shareholders, which have $160 and $40, and they contribute their money to incorporate a company. So it means the company initial share capital is 200, and then a company decides to have 100 shares. So actually they can have as many shares and as little share as they want, but let's assume that in this case they have 100 shares. So to calculate the price for each share, we divide the 200 to 100 shares that we have $2 for each share, which is called a nominal value of share. And when you substitute the nominal value of share to the initial contribution of each shareholder, you will get a shareholder A with 50 share, a shareholder B with 30 share, and the shareholder C with 20 share. So this is about the share, some explanation on some basic term of company share capital. Next, we will move on into the requirement on what can be considered and contribute to a company as a capital. So in the section 582 of Company Act 2006, they state that share allotted by a company and any premium on them may be paid up in money or money worth, which is including goodwill and know-how. And in the section 583 of the same act, there are some explanation on cash considerate of payment of company capital, which is a cash consideration. Cash consideration can be a normal cash that received by the company, or it can be a check received by the company, or it can be a release of a liability of the company for a liquidate sum, or it can be an undertaking to pay cash to the company at a future date, which is like a promise to pay cash. Or lastly, it can be about the payment by any other means giving rise to a present or future entitlement to a payment or credit equivalent to payment in cash. Moreover, in the section 593, the Companies Act 2006 state that for public company, they can receive non-cash payment, which is need a valuer to evaluate that non-cash assets, and then they will send a report to a company, and when that value is agreed by a large part of shareholder, they can contribute their non-cash assets to the public company. The same thing is happened in Vietnam, where in the article 34 of Vietnamese law on company, the assets that can be contributed to a company is beside of cash like Vietnam Dong or some other currency, cash and gold. They also have something like the ownership of real estate or the some, like, how can I say it, intellectual properties or some technology skill or other thing that can be transferred into Vietnam Dong. So there is more rule on this. Why? When a person who contribute a non-cash asset to a company must prove that they must prove their ownership on the assets that they want to contribute to a company. On the article 36 of Vietnamese 36 of Vietnamese law on company, they also have more detail on the contribution of non-cash payment of share to a company, which is they say that they say that there need to be a valuer, like in UK law, they need to be a valuer that evaluate the non-cash assets, and that evaluation needs to be made into a report, which is also needs the acceptance of a large part of company member to be considered as a official asset of a company. So if you remember the case that we have learned on some of the first date in company law subject, which is about Ted, Charlie, and Sasha. And in that case, when Ted have the idea on his like his business, and Sasha have the idea of the logo, their assets is considered as a non-cash asset, and the Charlie who is contribute a purely cash to the company, and his assets is considered as cash assets. And if the three people of them decide to make a company and need to like transfer their properties into money, they will need a valuer to evaluate their intellectual assets. Let's move on into the last part of our presentation, which is the requirement of minimum share for each type of company. So in this case, we will divide it into two types of company, which is private and public company. So in the UK, there's no requirement of the minimum share capital for private company, but in the public company, they will need to have at least their share capital need to have at least 50,000 euros they will need 50,000 euros to form a public company. This is stated in the section 761 subsection 2 and the section 763. So these are the things. So we have covered everything we know about incorporation of a company. I guess we will stop here, and if you have any question, please feel free to ask us. Thank you for listening.
Okay. So thank you very much. Do you have anything else? Presentation group? Do you have games or something else?
Hết rồi thầy ơi.
Hết rồi đúng không? Hết hẳn luôn đúng
Yeah.
không? Okay. So thank you very much for your group's presentation. Okay, so overall, I think it's a good presentation. Okay, I think all of us agree this is a good presentation because it's presented a lot of ideas revolving the problem of incorporation. So after today's presentation, the whole class, you should remember these things below. First, you should remember the requirements on the form of submission, the submission form to establish a company. So you have to remember where you should send the form to, and who you should send the form to, and what information you should include in the form. So you should remember that. And the second content, you should remember the requirements on company's name, okay, which is very important too. The third one, you should remember about the requirements on capital. Okay, so just as Tín just presented to us. And the fourth one about the personnel. Personnel là nhân sự của cái công ty. About the personnel of the company. Okay, so you should remember how many shareholders, maximum and minimum, that is required when you form each type of company. Okay, and you should also remember the number of directors and the requirements to be a director. Các điều kiện để trở thành một director, để chọn một cái director cho công ty của bạn là gì? Và bạn phân biệt được giữa shareholder và director, phân biệt được giữa tư cách thành viên của hai anh chàng này là như thế nào. Và khi bạn đăng ký thành lập doanh nghiệp thì bạn phải đăng ký cái đó, phải đăng ký cả hai người này. Ok, thì bạn nhớ chủ yếu là những cái nội dung này. Ok, which is very good. Có một cái nội dung mà thầy chưa thấy nhóm mình đề cập đến á, đó là cái ok, khen trước ha. Ok, so overall your group makes a very good presentation because your English is good. There are although some members whose English was not very good, but I think they can improve more on that. It's typically I think that should improve your reading, your speaking, and you should not pay too much attention to the script. Tức là Đạt đừng có nhìn vào tờ giấy mà đọc nhiều quá. Bởi vì lần trước khi mà bạn nhìn vào tờ giấy xong rồi bạn đọc tiếng Anh lên á, người ta sẽ biết ha. Thì cái nội dung của bạn ở phần của bạn Đạt á rất là tốt, nhưng mà cái cách mà bạn trình bày, bởi vì bạn đọc á, cho nên là nó đâm ra nó bị giống như đọc văn bản và nó trở nên hơi là lê thê và nó khó theo dõi. Cho nên là mình cố gắng improve cái English của mình. Một cái mánh để các bạn improve English á, là các bạn think in English, tư duy bằng tiếng Anh luôn. Thì cái đó sẽ giúp cho các bạn English tốt hơn ha. Trung Tín and Trami did a very good job, and Vĩ too, although today's Vĩ is unlucky because his voice is not good, so I wish you get better soon. And K.Anh also, yeah, K.Anh spelling is quite good, but you made a few mistakes in English, but it's forgivable, so I think it's okay. Okay, and có một cái này mà thầy thấy là nhóm mình chưa có đào sâu vào, nhưng mà nó cũng là một cái nội dung khá là hay, đó là về promoters. Thì nhưng mà bởi vì là nhóm tiếp theo đã làm về promoters rồi, hình như là như vậy, đúng không? Nhóm tiếp theo, nhóm list mình làm về promoters đúng không? Nhóm list có phải làm về promoters không?
Dạ.
Các em làm về promoters đúng không? Nhóm list.
Dạ không đâu thầy ơi.
Chủ đề của nhóm list là cái gì em?
Dạ là peer incorporation contract and translate of liability.
Okay. Pre-incorporation contracts thì nó sẽ liên quan đến promoter đó. Rồi ok, cho thầy hỏi là nhóm list có bao nhiêu slide? Thời gian dự kiến làm bao lâu?
Chắc khoảng 15 phút rồi thầy.
Gì đâu có 15 phút thôi hả?
Có 10. Dạ, được có 1/7 của cái nhóm đầu rồi thầy.
Một chủ đề lớn như vậy mà nhóm làm có 15 phút thôi hả? Wow. Ok, nếu mà như vậy thì ok, nếu như vậy thì bây giờ mình sẽ nghỉ giải lao hai lớp. Mình sẽ nghỉ giải lao trong vòng 20 phút, sau đó mình trở lại. Rồi nhóm list sẽ bắt đầu thuyết trình. Ok.